Here at Scott Legal, we know the ins and outs of immigration. We are here to help you navigate the oftentimes complex road in achieving your goal of permanently living and working in the United States. How can a criminal act affect a person who is a legal permanent resident of the United States? A legal permanent resident can be affected by a criminal act in one of several ways. 1. A legal permanent resident can be disqualified from applying for citizenship or have her citizenship application denied if an immigration officer believes the legal permanent resident does not deserve to be granted citizenship status because of the circumstances of the criminal act. 2. A legal permanent resident can be subject to losing her status and being removed, which is the same as being deported from the United States if convicted of a certain criminal offense. 3. A legal permanent resident that may be subject to being removed from the United States can be disqualified from being able to ask for her offense to be forgiven. So, what criminal acts will affect a legal permanent resident of the United States in attempting to obtain United States citizenship? A major requirement for citizenship is for a legal permanent resident to demonstrate that she is a person of good moral character. Therefore, there are generally 3 types of crimes or criminal acts that can affect a legal permanent resident's attempt in seeking citizenship. The first type of crime or criminal act are those that create a permanent bar to a finding of good moral character. The second type of crime or criminal act are those that create a conditional bar to a finding of good moral character. Conditional bar crimes disqualify from citizenship if they happen within the statutory period of 5 or 3 years for naturalization, including the period prior to filing and up to the time of the oath of allegiance. The third type of crime or criminal act are those that can lead to a finding that the applicant lacks good moral character based on the circumstances of the crime. Note that some of the unlawful acts or conditional bar crimes have exceptions that excuse the act or require a case-by-case analysis where extenuating circumstances can lead to a finding of good moral character, despite the criminal act. Finally, some crimes that are state court convictions can be argued to not have the necessary elements to be considered a disqualifying criminal act or conviction. So, what criminal acts put at risk a legal permanent resident status? Depending on how a criminal act is defined by state statute, many crimes of violence, crimes involving theft and crimes involving drugs may place a legal permanent resident at risk of losing her green card and being removed or deported from the United States. In determining whether a criminal act makes a legal permanent resident deportable, we look at whether the act is considered an aggravated felony, a crime involving moral turpitude, or a drug-related offense. In state drug-related offenses, we need to determine whether the drug known as a controlled substance is also illegal under federal law. All federal drug offenses expose a legal permanent resident to removal. Crimes involving moral turpitude are not precisely defined under immigration law. Immigration courts have given some guidance in attempting to identify these crimes, stating that these types of crimes are crimes comprised of behavior that is depraved or against the accepted morality standards and obligations between people who make up society. Although it is not always clear whether a state criminal conviction is considered a crime involving moral turpitude, this ambiguity serves to also provide the opportunity for argument that a state crime conviction does not contain elements comprising a crime involving moral turpitude. What are aggravated felonies? Aggravated felonies are easier to identify because the criminal acts considered to be aggravated felonies are actually listed by immigration law. Does a legal permanent resident subject to removal because of a criminal act have any option in keeping her status and avoiding removal? A legal permanent resident who has maintained her status for at least 7 years has the option to apply for a waiver before the immigration judge presiding over a case, known as the application for cancellation of removal for certain legal permanent residents. This application allows an immigration judge to deny or grant the application after weighing positive and negative factors in the legal permanent resident's life, which if granted would return the status and allow her to remain in the United States. In some cases, a legal permanent resident with a qualifying family member can also reapply for a green card seeking waiver of the offense before the immigration judge. However, depending on the criminal act, some criminal acts will disqualify the legal permanent resident from seeking cancellation of removal or in asking for the waiver. If the legal permanent resident has been convicted of an aggravated felony, such a conviction will disqualify the legal permanent resident from the benefit of applying for cancellation of removal. Are there any other issues that a legal permanent resident subject to removal should be worried about? A legal permanent resident facing potential removal because of a criminal act may be forced to stay in immigration detention jail, even if eligible to apply for cancellation or a waiver. You can view our video explaining the removal process by clicking the link below. In any case with criminal history, it is important to seek the advice of one of our immigration attorneys to evaluate the acts and determine whether the crime can be challenged as not being one that disqualifies the legal permanent resident from the benefit she is seeking, or to determine whether the legal permanent resident can seek a waiver of the offense if subject to removal. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below. We are here to help. You can contact us by calling 212-223-2964, or by sending us an email. We look forward to hearing from you. You can also schedule a consultation by clicking on the link below, where you can choose a day and time that is most convenient for you.